Welcome back to CNBC Africa's The Entrepreneurial Edge, where we look at the role of mediation and litigation in conflict resolution. Still with me in studio is John Brand, Director and Alternative Dispute Resolution Specialist at Bowman Gilfillan. And joining us for the second half of the show is Wahida Parker, CEO at Equilaw. Thanks to you for joining us in studio, Wahida. Well, we've looked at mediation quite extensively in part one of the show, exploring both the pros and the cons. We've got your company specializing in developing mediation cultures in various and diverse territories. What's the motivation behind it in your books?
The motivation is, I think that is the way the world is going, and John mentioned that earlier. I think it's important to recognize that a milestone in this country will be when King 3 comes into effect. And entrepreneurs especially will take a more careful look at where they spend shareholder money. In the world in general, the subprime crisis currently is being dealt with through a process of mediation. There is a recognition that traditional processes such as litigation no longer serves the world's interest, and therefore it is time that we take this on board and give effect to it. It's not something that's unknown to us. It's really not new territory. It's just about extending the territory into the field of commercial disputes.
For it to have that desired effect, though, one would assume business would have a structure and design that needs to facilitate this process going forward, and so to an extent reorientate the way the organization is structured before, so that it has the right mechanisms in place before conflict actually arises, so that there's an early warning system, if we can call it that, that's triggered. How do you go about structuring things so that there is this system in place?
Absolutely, Alicia. I think the critical thing is a culture change. It's a mind shift how we conduct ourselves when we are confronted with conflict. And that takes time. I don't think it's a flick of a switch. I think it's a matter of people taking these concepts on board and internalizing them. The second aspect, which is critical and important, and maybe doesn't take that long, is committing yourself to these processes when you engage with service providers, with your employees, ensuring that every contract you enter into makes provision for mediation as a first step in the process. If you don't do that, it's very difficult after the dispute has arisen to bring the other party on board. Yeah. So I think it's important to do that. And then lastly, many international organizations are opting for what we call a mediation pledge. And what they say through this is that in every aspect of our business, whether internal stakeholders or external stakeholders, we undertake that these are the principles and these are the processes we would use to resolve disputes.
Well, John, this is these supportive structures are premised on the fact that it's not a game, and the objective at the end of the day is to reach a settlement, and that's just the blank reality we face.
Yes, Alicia, and a point that I don't think has been made perhaps sufficiently is that our courts are hopelessly overloaded with cases. The waiting time to get into court in Gauteng at the moment is in the region of 3 years, and no business can wait that long to resolve the disputes. So I completely agree with Wahida, but I also think culture change requires a little bit of encouragement as well from the authorities. And so it's very, very encouraging to see in the draft a very, very strong emphasis on referring matters to mediation. But I think it's also necessary for our rules of court to be amended in the way in which the rules of court have been amended in other countries to put pressure on parties to go to mediation first. I think the judges need to be far more activist than they are and follow the path that their brothers and sisters have pursued in other countries, and that is to make adverse costs awards against those that won't adopt the new culture. But we can't sit back and do nothing. Another point I think that is important, and it goes back to investment, is that foreign investors are getting used to a different way of resolving conflict in the countries they come from. And they expect us to be up to date in Africa and in South Africa in particular.
Well, Hida, it's one thing, though, having businesses and expecting them to rise to the challenge here. Are enough people actually trained to deal with conflict and, more specifically, facilitate mediation processes?
I think that has already started. John mentioned earlier, we certainly, as a founding sponsor for the Africa Center for Dispute Settlement, are hosting courses to ensure that as there is this growing awareness, we're able to meet the need when conflicts arise and when mediators are called on. John has mentioned earlier as well, we have a rich history of conflict resolution in this country. We have got some very experienced mediators, and what we've got to do is grow that body and make sure that we are able to meet the needs of the people out there. But it's certainly happening. I'm very supportive of what John is saying in terms of we need intervention from a legislative point of view. And what is encouraging is that new pieces of legislation that are coming out now certainly call for mediation as a first step in the process.
Well, obviously, both of you have highlighted the King report. How does the King Commission envisage that directors actually comply with this duty going forward, John?
Excellent.
Well, they say in the draft report that directors need to appreciate that there are alternatives to litigation. They highlight the shortcomings of litigation, and they say that parties need to consider arbitration, and they need to consider mediation and a variation of mediation called conciliation in particular. And then they go to considerable length to explain the benefits of that. And that's what they envisage happening. And of course, we need to make sure we have in place all that is necessary for the business community to make that move to mediation. And I think Wahid has already said we do have now a very, very strong group of commercial mediators trained, and I may say accredited to international standards. I think all the organizations we're associated with realized that if we wanted to succeed in South Africa, we needed to offer the business community mediators of world standards. So that's in place. The services are in place. Wahida heads an organization which has a panel of commercial mediators. There are others like Takisa Dispute Resolution and AFSA that provide commercial mediation services. So the building blocks are being put in place.
Wahida, you had a comment on the back of that.
Yes, especially with regard to King 3 and your question about how we're going to ensure that directors take heart of what is being proposed. And again there I was envisaging something almost like, you know, what is it, South African Bureau of Standards, saying we committed, and that's where the pledge comes in. You know, you're going out publicly saying this is what we're committed to, and people should be encouraged to put that on their websites so that when I want to do business with an organization, and if I see that mark, I recognize it as an organization that deals with their disputes in a particular way.
And it also, to an extent, would settle concerns about adherence. I mean, seeing that this is certainly not a judgment that's been dealt down by a judge in a court of law, one would question the effectiveness of this in terms of adherence, and that could offer some relief in terms of just offering you some reassurances that adherence will be compliance going forward.
Absolutely, Alicia. And the wonderful news is that when you look at international statistics, when people reach an agreement during the process of mediation, compliance to that agreement is almost a fait accompli. You rarely find people reneging on that agreement because they are part and parcel of reaching it. They are actually the people who design the outcome and the settlement, and therefore they adhere to it much better than we find in court systems.
And of course, if we had to compare this, John, I mean, to litigation, if we do get to that stage, you're dealing, of course, with the costs, as we mentioned earlier. You're dealing with capital being tied up. You're dealing with reputational damage as well. If we do get to the stage, to what extent are you actually setting a legal precedent in that employees that are disgruntled with the company down the line may use this and see this as an avenue in the future as well?
Yes, I think that is so, and I just want to go back to this point about compliance. I spent many years of my life as a very adversarial litigation lawyer, and one of the things that frustrated me greatly and moved me in this direction was that even when you'd won your cases, when you came to execute on your judgment, you found that the company had disappeared, or the shares had changed, or the assets had been moved, and so you had these continual Pyrrhic victories. So the point which we had to make is a good one. If you get a settlement quickly and by consensus, it's much more likely that it's going to be complied with. But there are quite a number of other things that we need to do, and I think that it's also emerged from this is that the business community, I think, is not fully aware of the range of processes that there are. We focused on mediation, but there are others. They are not aware of its benefits, and we have a major marketing and education job, marketing and promotion by letting people know what is out there, getting into the business schools, getting into the law schools, and unlike other countries where alternative dispute resolution is an important part of the training curriculum. Yeah. You don't see that yet in South Africa.
So if we have to look at things, just to wrap things up here, Wahid, I mean, what does South Africa need to do to assist directors to carry out their dispute resolution duties?
I think a mind shift on the part of the legal practitioner is a critical element. Unfortunately, our labor legislation doesn't allow for representation by lawyers. And somehow it appears that legal practitioners believe that in commercial mediations they are excluded. That is the perception is completely incorrect and should be rectified. I think they're going to play a critical role in advising their clients at a professional level. I mean, if I'm a lawyer and I know that King says I've got to look at alternative dispute resolution mechanisms professionally, what is my responsibility when a company director comes to me with a dispute? Yeah. And I think that's the interesting aspect of ethically, how will the attorney deal with it? Where does his obligation lie? And they should not be thinking of this in terms of excluding themselves from the process, but rather take it on board, because this is really the way the world is going to go.
On that note, Wahida, let's leave it there. Thanks to you as well, John, for having joined us in studio today. And on that note, that's how we end this episode of the Entrepreneurial Edge. Now, if you have any questions on this evening's topic or entrepreneurship in general, you can email Sasfin or the CNBC Africa team at the address you see on screen right now. And for more information on this and other CNBC Africa shows, do visit our website on www.cnbcafrica.com. From me, Alicia Second, goodbye.